This is Eyewitness News.
A COVID-19 reporting requirement on the horizon for California employers. Long Beach community journalist Rachel Jordan looks at a new bill proposed here in California.
As more people head back to work amid the pandemic, you may have questions about COVID-19 and the workplace. So we spoke to an employment attorney to find out what laws are in place when it comes to virus disclosure.
There are no laws that specifically mandate an employer to advise their employee that someone is tested positive, that they've been exposed. So it's not mandated, but it's definitely advisable.
Different agencies like CalOSHA and the CDC advise that employers notify their employees if they've been exposed to COVID-19 at work. But State Assembly member Luis Reyes wants to make it a legal requirement. Reyes introduced AB685 in June, which would mandate an employer to notify employees, CalOSHA, and the Department of Health if an employee possibly exposed other employees to COVID-19 in the workplace. But the big issue with disclosing possible COVID-19 exposure on the job is privacy, as employees have the right to confidentiality for all health-related matters, and AB 685 addresses that.
Names are not going to be mentioned. You will simply be told, just as we do with contact tracing now, you'll find out that you've been exposed to someone who tested positive for COVID-19.
As it stands now, businesses in LA County are required to report outbreaks to the health department after at least 3 people have tested positive for the virus. Several factories across LA County were shut down in July after failing to report outbreaks to health officials. But Reyes hopes the bill, which will be heard by a Senate committee in the coming days, will streamline regulations.
There is this disparity from county to county, from locality to locality, from industry to industry. And we do have to have something that is going to be more uniform to protect all of California's workers.